Roe v. Wade by Rebecca Andrus and Peyton Crow. Precedents and related cases that influence the court's decision. During and before the early 19th century, there were no regulations on abortion, and it was common practice, as long as it was before fetal quickening, also known as movement from the baby in the womb. In 1857, the AMA began criminalizing abortions for all cases except for when the mother's life was at risk. The AMA had far-reaching influence, and by 1880, every state in America had introduced a criminal abortion law, but they were still being performed and prosecuted unevenly. In 1959, ALI proposed to make abortions legal and broaden the circumstances to cases of fetal abnormality, rape, incest, or when it threatens the mother's life. Within a decade later, in the 1960s, during a social awakening, abortion laws became more lax. A related case is Griswold v. Connecticut in 1965. Connecticut had a law prohibiting everyone, including married couples, from using birth control or any form of contraception. A Planned Parenthood clinic opened in New Haven, but the workers were arrested and the building was closed for breaking the contraception law. The Supreme Court later struck down this law with a 7-2 decision and authored by Justice Douglas. SCOTUS ruled that the Constitution did in fact protect the right of marital privacy against state restrictions on contraception. Griswold also invoked the idea of penumbras, or implied rights, and helped to establish the right to privacy, which is very important in the decision of Roe v. Wade. Results of that case influenced new state legislation. Some states like New York, Alaska, Hawaii, and Washington decriminalized abortion. 13 other states increased leniency of the law, and the rest continued to criminalize abortion. Here's some background information on the case Roe v. Wade. During the 1960s, having or performing an abortion in Texas was illegal for all cases except for when the mother's life was endangered. The plaintiff was Norma McCorvey, who used the pseudonym Jane Roe. She had been pregnant twice before and put both children up for adoption, and she became pregnant for a third time and wanted to safely terminate the pregnancy. She is joined by Texas attorneys Linda Coffey and Sarah Weddington. The defendant is Henry Wade. He is the district attorney of Dallas County, Texas, where Ms. McCorvey lived. Roe first went to the Texas State Court in 1969, and the judge agreed that Texas's abortion ban was unconstitutional and vague, but did not have the power to change it. Despite the ruling, Wade vowed to continue criminalizing doctors for performing abortions, so Roe appealed to the Supreme Court. Before the case can even reach SCOTUS, McCorvey gave birth to her child and gave it up for adoption because the law had not yet changed. Constitutional questions and applicable laws. The judges were trying to answer these following questions. Are the strict abortion laws in states like Texas and Georgia constitutional? And do women have the right to abortions? Some applicable laws are the 14th Amendment, which prohibits states from depriving any person of life, liberty, or property without due process of law. The Due Process Clause is reasoned to be a fundamental right to privacy that protects a woman's decision on the matter of pregnancy termination. Roe alleged that the state laws were unconstitutionally vague and infringed on her right of personal privacy protected by the 1st, 4th, 5th, 9th, and 14th Amendment. This is the actual court decision of Roe v. Wade. The Supreme Court ruled with a 7-2 vote in favor of Roe that the Texas law was unconstitutional. The justices felt that the criminalization of abortion in the state of Texas, especially restrictions in the first trimester, was unconstitutional and violence against women's rights to privacy. The right to privacy was established in the previous case we talked about, Griswold v. Connecticut. The dissenting opinion of the two was that the court did not have the authority to strike down state laws, and abortion restrictions were taking place during the ratification of the 14th Amendment, so using the 14th Amendment against the abortion law was not valid. They also created the trimester approach, which was used widely afterwards. This is the trimester approach. Within the first trimester, a woman's privacy and desires trump the state's interests, so no abortion regulations during this time. In the second trimester, the state's interests in protecting the woman from dangers of abortions increased, so some intervention and regulation during this time is allowed. But in the third trimester, the fetus is considered to be able to survive out of the womb, thus constituting outright ban at this time. And women are only allowed to abort when the mother's life is on the line. The Supreme Court makeup during the Roe v. Wade case is as follows. The majority opinion has the Chief Justice Burger, Republican, Blackmun, Republican, Douglas, Democrat, Brennan, Republican, Stewart, Republican, Marshall, Democrat, and Powell, Republican. The two dissenting opinions are from Justices White, Democrat, and Rehnquist, Republican. Possible rulings and decisions in this case. The court held that a woman's right to an abortion was implicit in the right to privacy protected by the 14th Amendment in the Constitution under the Due Process Clause, which states, "Nor shall any state deprive any person of life, liberty, or property without due process of law." In Justice Blackmun's opinion, that only a compelling state interest justifies regulating, limiting fundamental rights such as privacy, and that legislators must therefore draw statutes narrowly to express only the legitimate state interest at stake, to balance compelling state interests in the health of pregnant women and potential life in fetuses. States could regulate abortion after the end of the first trimester. In 1965, Griswold v. Connecticut case set the legal precedent when the court determined citizens have the right to privacy involving medicinal procedures, which includes abortion. Impacts of the ruling. Roe v. Wade legalized abortion in the United States, which effectively ended the millions of back-alley abortions that have taken place in America for the past couple of decades and reduced the number of births per year. Roe v. Wade's court decision set the legal precedent for 30 subsequent Supreme Court cases involving restrictions on abortion, which upheld the decision that women have the right to choose what they want to do with their bodies under the right to privacy involving medicinal procedures. The issue has greatly impacted politics and society, with both pro-life and pro-choice having great influence over our politicians. Since 1973, states have passed laws to regulate abortions even further, such as Alabama's law, which only allows for abortions when the mother's life is in danger, but does not include rape or incest cases, meaning if you are raped in Alabama, you are required to give birth to the child. The Hyde Amendment, passed in 1976, blocks federal Medicaid funding for abortion services, making it harder for some people to access.
Abortion remains a sensitive topic, and states continue to make laws restricting women's autonomy. These new legislation, like the ones created in Georgia 2 years ago, put people with uteri at risk. Just because they become illegal does not mean people stop receiving abortions. It just means they are not safe and less accessible.
Here are two similar cases to Roe v. Wade. The first case, similar to Roe v. Wade, is Whole Women's Health versus Health Step in 2016. The petitioners, a group of abortion providers, sued Texas to invalidate some provisions stated in the House Bills 2 and argued that the bill denied equal protection and unlawfully delegated lawmaking authority. The main question was, should a court's substantial burden analysis take into account the extent to which laws that restrict access to abortion services actually serve the government's stated interest in promoting health? The court voted 5-3 in favor of Whole Women's Health, stating that House Bill 2 imposes an undue burden on women seeking a legal abortion and thus is unconstitutional. The second case, similar to Roe v. Wade, is June Medical Services versus Russo, Act 620, which is extremely similar to the House Bill 2 in Texas, but this was passed in Louisiana, which required that every physician who performs or induces an abortion shall have active admitting privileges at a hospital that is located not further than 30 miles from the location at which the abortion is performed or induced. The district court hearing the challenge to Act 620 determined the law would drastically burden women's rights to choose abortions. The major question of this case was, does the decision by the U.S. Court of Appeals for the Fifth Circuit below, upholding Louisiana's law requiring physicians who perform abortions to have admitting privileges at a local hospital, conflict with the court's binding precedent in Whole Women's Health v. Halstead? The Supreme Court voted 4-5 in favor of June Medical, reversing the law that requires abortion providers to hold admitting privileges at local hospitals. A meme or helpful mnemonic device would be, I brought you into this world and I can take you out. Just be aware that the court's trimester approach states that only in the first and second trimester can you actually take them out of this world.
Here are works cited. Thank you for listening.